question. I tried to ask the government.
Yeah.
I think maybe they didn't know yet. You may not know either, and suspect you haven't talked individually with every one of your class members. But do you know if anyone is currently being detained under the Alien Enemies Act proclamation and not being detained under any other legal ground?
I don't know the answer to that. I suspect that most people, maybe all of them, are being detained under the immigration laws because they were in proceedings. I mean, the government is using the act to try and short circuit the immigration proceedings. And so I think what they have done is pull people out of proceedings and put them on the plane to El Salvador. So
your original complaint mentioned apprehension and removal, and you wanted to enjoin both. I understand the district court did not take you up, did not accept your invitation to enjoin apprehension, but that does suggest that you were worried there would be some class members currently at large in the country who might be apprehended under this AEA authority.
So Your Honor, I think to the extent that that language is in there, it may be inartful, but we're 100% clear with Judge Boasberg, and he has been 100% clear. We are absolutely not trying to get anybody out of detention, stop anybody's removal, stop anybody's prosecution. And I think that goes to the larger point. This is a very specific statute, a wartime statute dealing with a very specific problem. It does not bar any of their authority for prosecuting or removing these individuals, much less have to do with anything about stopping ships in China.
Can I ask you about Munaf v. Guerin? Because I do understand how you can read it to the government here, and you can read it to help you here. I think the government is saying the first thing the Supreme Court held there was there is habeas jurisdiction. This is someone who wasn't objecting to being held, but was objecting to being transferred from U.S. custody in Iraq to the Iraqi government in Iraq, and said, don't transfer to the Iraqi government. And the first thing the Supreme Court held was that there is habeas jurisdiction for that because he was an American citizen. And then said, in your habeas cause of action, you lose on the merits, right? Because we're going to respect the Iraq's kind of what they said is Iraq's exclusive jurisdiction to punish offenses against the laws committed within its borders. So we have habeas jurisdiction, and habeas is your cause of action. But with that cause of action, you lose on the merits because of Iraq's exclusive jurisdiction to punish offenses against its laws committed within its borders. And if that's how it's read, it seems like Munaf is a pretty good precedent for the government saying, look, if you want to challenge your transfer from U.S. custody to another nation's custody, your cause of action is habeas.
Well, I think two things about that, Your Honor. One is Munaf said you could do habeas. It didn't say you must habeas. And I think that's the difference in these core habeas cases. Whether you could bring it in habeas, you often can bring it in habeas, but then whether you must bring it in habeas. So we understand the Chief Justice to be saying in that case, I think it was fairly clear, the last thing you want is simple release.
Right.
And so I think that's why Munaf doesn't answer the question. And Thursingham, of course, is the most recent precedent from the Supreme Court.
On the not having to bring it as habeas, the district court understands your cause of action to be an APA cause of action. I think the government says this is a presidential proclamation. It's different than an agency proclamation. I think last time I was on a panel and you were the attorney, it was an agency proclamation. And you can bring it, we see every day in this court challenges to agency order under the APA. But if there's a challenge to a presidential order, the APA is not typically the vehicle for that. And Franklin v. Massachusetts says, at least as a general matter, it can't be. I think what you'll say is, at least on the individualized determinations of whether the class members are part of Tren de Aragua, you're going to use the APA to challenge decisions that are being made by lower level officials. To me, that, if true, just indicates that there's not the type of commonality for a class that you need in order to certify.
Right, Your Honor, so a couple of things. One is that we cited multiple cases that say even where there's a presidential proclamation, you can challenge its implementation by the agency. But to your common question, our common questions are obviously first, whether the AEA can be used at all against a non-foreign government. But the second question is, are they entitled to process? So at some point, if there's individual determinations about whether you fall within the proclamation, those obviously will be all common. But the initial question that we're fighting with the government about, and they're still, I think, grudgingly only conceding it, is whether they're entitled to some process. They clearly have not been given process, but for this action, I don't think the government would be conceding what it had to concede.
What's the status of the habeas petitions in Texas, the ones that have been filed and that are ongoing?
Yeah, that's a good question, Your Honor. We've been trying at council table to find out a little bit about where they are. I think they're generally on hold. And those individuals, there were few habeas petitions, very few people who happen to sort of guess that maybe their person is going to be designated. But for the vast majority of people, they haven't been designated. I wanted to also clear up one point of confusion. The government keeps reading from the transcript at page 41 that the judge's initial TRO, I mean, the judge has obviously made clear this morning what his TRO is principally based on. But the judge's hearing transcript on Saturday night was very clear that he was also talking about process. And that's at pages 29 and 30, starting at line 25, Your Honor, where he was very specifically talking about process, and footnote 17 in Ludecky that said you have to be able to contest whether you fall within the proclamation. So I'm sorry.
I want to ask about, I guess this goes to some degree, I think it goes to the irreparable harm the government asserts.
Right.
And to some degree to maybe larger issues. And so the question I'm going to ask you is going to sound like I have some skepticism about what the district court did on Saturday. I want to preface that by saying we've had a week to look at this issue and it's been hard. And the district court only had a day.
Right.
You know, about a decade ago, one member of this court, long before I was on it, talked about district judges having to deal with Guantanamo issues. So they were difficult and intricate and complicated and novel. And he said, even when this court might disagree with the district court decision, that disagreement is with respect for the dedicated work of the district court. These matters. That said, I'm wondering if you can point me to a district court TRO or injunction that survived appeal that stopped an ongoing, partially overseas national security operation in the way that this, at the time at least, did order planes to take foreigners from international waters to the United States.
Your Honor, so to start with, the order about him bringing people back, potentially bringing people back, is not before you. And I think there's a lot of factual development. And I don't know how much this court is aware, but there have been emergency proceedings almost every day. And I think the district court has not been pleased with how the lack of forthcoming attempt.
I just added that though.
Yeah, and so, but that,
there's this declaration by, it says that he's been at the State Department since 1971.
How was that?
54 years ago. My math is right. That's quite a lot of experience in the State Department. Now he's a career State Department official, head of the Western Hemisphere's Affairs Bureau. And he says that this TRO is, quote, harming the foreign policy of the United States. It comes after, quote, intensive and delicate negotiations with El Salvador and the Maduro regime, risk the possibility that those governments will change their minds. It gives them leverage for renegotiation. And he warns, quote, these harms could arise even in the short term. So, I mean, those concerns are ongoing. I understand that there are no longer planes in the air that are being ordered to return to the United States with foreigners that the executive branch doesn't think should be in the United States. I guess just maybe from a 10,000-foot perspective, I thought about when Justice Douglas enjoined the bombing of Cambodia, but it didn't go very well. The Supreme Court reversed him in about 6 hours. I found a couple other injunctions that are somewhat analogous, but they didn't survive appellate review either. Can you, standing here, give us an example of a district court injunction that enjoined a national security operation partially overseas that survived appellate review?
Well, Your Honor, I want to push back on the overseas part because I don't think the order to return the planes is before you. So what we're talking about is not sending people, and that is
Foreign policy
straight
implications,
removal.
the
But
negotiations with
okay,
the Bureau
so
regime.
let me address that. So
Well, can-
yeah, I know.
I will not stop you from having time to address that, but can you just tell me what's an example of a district court enjoining a national security operation with foreign relations
Right.
implications? I think we could at least agree on that.
So I think, like, for one thing, I would cite Boumediene, with the Supreme Court saying there has to be habeas. I mean, the government could not have argued more strenuously that the court should not interfere and say that they're entitled to habeas while they're at Guantanamo. But to your point about the national security, I want to return to something that Judge Millett said. The government cannot take the position that it's an interference by this court on national security grounds to give people process. The Supreme Court was 100% clear in Ludecky in footnote 17 in multiple cases saying process. So for the government to say you're interfering by giving what Justice Frankfurter said in Ludecky was necessary as a matter of the act, and I don't even think he needed due process. He was ruling as a matter of the act. You have to be able to contest. The implications of not giving people a chance to contest it are extraordinary. I mean, every religious and ethnic group in this country has at some point been tagged as associated with a criminal organization. If people can just be picked up and sent.
Mr. Galern, I mean, I just have to stop you. You're not getting an argument from this bench
Okay.
so far today against the idea that every single member of this class
Okay.
can have an individualized habeas determination in front of an Article III judge to say, I'm innocent. And I think I take your point about Boumediene and your point about Ludecky, but I think it's hard to answer some of our questions without mentioning cases that are habeas cases. Boumediene was habeas, Ludecky was habeas. And so it seems like in order to answer one question in a way that is kind of satisfactory for your position.
Well, that's because they were asking for release.
But you are asking to stop a transfer, and that is something that habeas has been used for repeatedly.
It could be used, but it doesn't have to be used. And we, of course, but I think, Your Honor, I want to return maybe to the very beginning of this appeal. We don't think there's jurisdiction over a TRO. I mean, you just had the decision in Dellinger. That's a very, very rare thing for this court to find that a TRO is appealable. And there are two preconditions. One is that it's a mandatory injunction not preserving the status quo. Judge Boasberg was explicit that he's simply preserving the status quo. And the other thing is that the harm can't be undone. You cited Mr. Kozak's affidavit. That's the last sentence in a two-page affidavit, which says there would be harm, but then he switches to could when he's talking about the short term. And all we're saying is that,
I think that we as judges don't know everything that the State Department knows.
Well, I think there's a reason why he switched from would to could in that sentence when he was talking about the short term. We're here asking that Judge Boasberg be allowed to do his work. And I think counsel for the government repeatedly answered questions to this panel by saying, I don't really know, there's not a factual record yet.
How do you just, on the question of whether this TRO is the type of normal TRO that can't be appealed or is the type of unusual TRO that can be appealed? We have this Adams v. Vance case from 1978. It says that you can appeal that TRO, and he called it an intrusion on executive discretion in the field of foreign policy. I mean, I know you maybe don't think that's what's going on here, but the government argues that that's what's going on here. So it seems like if you lose on the sort of merits of this argument, you should also lose on the is it appealable part.
Well, I think, Your Honor, that Adams was very different because it was a mandatory injunction telling the Secretary of State what to do. And this is very different. It's preserving the status quo. And there was also a fuller affidavit.
I understand the planes are on the air now, but it was not preserving the status quo when the planes were ordered to be turned around.
Well, Your Honor, again, I'm not sure I have much more to say on that other than that is about whether a district court's order, a federal judge's order was violated, but he still has not made any determination. So it is not before you. In saying that keep these people on the ground, don't let them be removed under the Alien Enemies Act. This is an unprecedented move to use the Alien Enemies Act for only the fourth time in our country's history without a declared war. He's saying preserve the status quo until we can find all the facts. And I think what we're going to show in the district court is that many, if not most of the people removed had no connection to the gang, that the gang does not actually have a formal structure with members. We're going to put in evidence about what happens in a Salvadoran prison, that you could remain there for the rest of your life. We're going to put in evidence, hopefully, about what the timing was and who signed it. President Trump has introduced confusion about now whether he actually even signed the proclamation. So all we're saying is that Judge Boasberg is working very hard.
No doubt. Sorry, you can finish that sentence.
No, I was just saying
he's working very hard,
and
that he has had to move very fast.
And I think we're going to move on a preliminary injunction very quickly. And I think for this court to sanction anything about what the government's doing, or even to say Judge Boasberg shouldn't have time to figure out what the process is, so it's not an illusory ability to contest, without a factual record, I think that is probably short-circuiting the way the system should work. I mean, we're really talking about something extraordinary to name a gang rather than a foreign country. This was a wartime measure meant for war.
Let me just, in terms of irreparable harm to your clients,
Right.
in terms of El Salvador prison that you just mentioned, all the things that you've just that you just articulated. What's your response to the government's argument? You can maybe do all that, but you just got to do it in the right court. And the right court is in Texas, not here.
Yeah, Your Honor, I just want to make, I want to answer that, but I just want to make one other point. The government seemed to be suggesting that this was about pre-deprivation, as if there wouldn't be harm if they were in a Salvadoran prison for a few days. But I don't hear the government saying if you win that habeas, we'll bring you back from the Salvadoran prison. So it's a little bit of, the question, I'm not sure I have more to say other than there is case after case, starting with the Supreme Court's decision in Prizer in the 1970s through Thurasingham, saying you do not need to bring a case in habeas unless it's a core habeas, meaning you are seeking release from detention. And Thurasingham was as strong as you can be on that. That, was a case that I argued, and it was unfortunate because we were asking the habeas be expanded, but that's where it's ended up. And that just builds on multiple cases from this court and from the district court, saying there's a difference between whether you have to bring it in habeas and whether you could bring it in habeas. And so, but at a minimum, I think Judge Boasberg is going to try and figure that out and decide what process, because if the TRO is lifted now, as Judge Millett pointed out, our people are on a plane. They're just on a plane. And so I think Judge Boasberg has done a good job of saying, here's an easy ground to say, if assuming it's appealable, here's an easy ground to affirm the TRO.
Why wouldn't 5 minutes after the TRO is lifted, why wouldn't your next move be to file a habeas petition in Raymondville, Texas, where they're being detained?
A class action? Well, we don't know that.
The 5 name plaintiffs.
Well, I mean, to begin with, we're looking not to just have our 5 named plaintiffs not end up in a Salvadoran
prison. If you're right
prison.
that a habeas class action is possible, you could file a habeas class action.
Well, I want to also make this point. The government is doing everything in secret. We have no idea if everyone's in Texas. So all of a sudden we see a plane leaving from Arizona and they say, well, you filed it in Texas. So I don't know if the government's asking us to file in every single district in the country, or whether they're going to specifically tell us where people are being designated and give us time to do it.
I mean, maybe, but the strangest place of all to file would be in Washington, D.C., where there's likely not a single person detained under the AEA.
Well, the people are being, I mean, just as a factual point, but I don't want to dwell on it. People are being moved from every part of the country. So we actually don't know whether people were originally in DC, because the government's not saying it. We know people.
Detention center in Washington.
Well, we know there could be in the surrounding areas, but I think that the proclamation is coming out of here. The agency heads who are enforcing it are out of here. And I think this is a fairly standard place to bring it. But unless, we can't even begin to figure out where to file all our habeases, even assuming a class action habeas, if the government's not going to tell us who has been designated in every district they're in.
You know where the 5 named plaintiffs are held?
The 5 named plaintiffs are in Texas now. They came from all over.
I would think they could file a habeas petition in Texas, and you could try to use those 5 named plaintiffs to represent a nationwide class. And I'm not saying you would get the class certified or you wouldn't get the. And that decision would be the right.
We're doing that. Why Texas versus DC? Just because the 5 named plaintiffs happen to be there at the moment. I mean,
Rumsfeld, the DA could have argued this. I mean, why? What was that?
Well, because those are,
could have argued this.
I mean, those are
supposed to file habeas where you're detained.
Well, only if it's a core habeas. I mean, the immediate custodian rule applies only where you're seeking relief because you want to be where the district director is. Your Honor, I may have sort of said what I can say about the core habeas. I think there's just too much law now to backtrack
There's such
on
a
that.
thing as a habeas class action.
The Supreme Court has ruled on the merits on habeas class actions. So, but it's an open question. And so if we went there and only had habeas and they said, for reasons unrelated to this case, we're not going to allow a class action, then I think our people would be back on a plane
And
in
then
El Salvador.
how many people do you represent right now?
Your Honor, I wish I knew. The government will not tell us who
You
they've
represent
designated.
more than the 5 names.
Oh, absolutely. It's a class. And
Every one of those is your client. that's in
yes,
the class.
absolutely, Your Honor.
And so every one of those would need to have you file a habeas action if you can find where they are and what district to do it in.
Absolutely.
instantaneously.
And then going forward, we'd have to know, the government has said they're going to continue designating people. And, you know, just to the point of, I get that we're now at a point where the government or this panel is not saying it's in some venue you can contest. But it's really an extraordinary thing that's happening because people were rushed out, as Judge Boasberg said, and story after story is now coming out that people had nothing to do with the gang. And so I think we're looking at people now who may be in a Salvadoran prison the rest of their lives. And I think that's really the problem. And incommunicado, families can't reach them. There's no way to reach them, and the government wants to continue doing it. And I don't, when Judge Boasberg said, well, how would the process work? And, you know, will there be pre-deprivation? Government didn't answer. And I hear the government also bringing up pre-deprivation again. So I just want to be clear that right now, as this is moving so quickly, I think Judge Boasberg has said, at a minimum, under Ledecky, the implementation of this proclamation cannot stand. And for that reason alone, I think the TRO has to be affirmed. We're going to move from a preliminary injunction. It will be back here, no doubt, from either
When are you
side
moving
on a
on your
full
PI?
record. I'm sorry?
When are you moving on the PI?
We're going to move in a couple of days, Your Honor, and we're trying to just gather as much facts as we can. Family members are seeing the videos of the harsh treatment men received when they got off the plane. They're alerting us. They're alerting us because they think the men have disappeared from U.S. detention facilities and they think they may be in El Salvador. We're also going to put in expert declarations about how the TDA gang works and that there's actually no formal membership. So figuring out who's part of TDA is very, very difficult, and a number of other factual developments. I would think this court, if it's going to rule on such an extraordinary issue, only the 4th time in history the act is being used, will want that full record.
And then I just had one other question. So Judge Walker has noted the difficult issues about the airplanes and stuff that
This is
Right.
Judge Millett
sort of mess
speaking
was
now.
happening on
Millett.
Saturday. The TRO, the written TRO says nothing about that. It just says
Right.
enjoined from removal. And I know that there's a bit of a kerfuffle in district court about those oral directions, and the government's position is those did not bind it. I think your position is that they did. So do we have to, if we were to be concerned about the TRO, at least as applied to directing airline flights out of U.S. airspace, but people still in U.S. custody, do we have to resolve that question of whether the oral language he was using at the hearing was itself part of the TRO?
I don't think so, Your Honor, because I understood that the district court to be sort of having 2 orders. The primary one was about going forward. He wants this enjoined so that and the other part was, let's try and stop the harm from occurring. So let's turn the planes around. Now that people are in the Salvadoran prison, the judge recognizes that the first step would have to be, was the order violated? The government says it wasn't violated because the planes were out of U.S. airspace, and there's a whole contentious thing going on. So I think it's.
I thought they said they now agree that they were bound by the oral. I thought they said that they were only bound.
They're still pushing back on that as well. I think Judge Boasberg has been fairly clear that he thinks the oral order was just as binding. But I think the question really has not been resolved in the district court. Judge Boasberg is first very meticulously going to try and find the facts about whether his order was violated and only then decide if there's a remedy. But he's certainly not going to do anything before he finds the facts. And I think it would be premature for this court to get into it because we're talking about the government potentially deliberately violating a federal court's order. And so I think it would be it would be best to allow Judge Boasberg to find those facts. Certainly the government, if he was to order them brought back, could come back up here. I can't imagine Judge Boasberg not staying that particular part of his hearing of his order if he ever got to that.
Mr. Lawrence, just a question about the timing of us deciding this stay motion. I know the government wants us to do it quickly. Do you see sort of the fairness of us deciding it fast enough that if the Supreme Court wanted to reverse us, they would have an opportunity before the TRO runs out?
Your Honor, but leaving the TRO in place?
Well, I'm not saying whether you or lose, so I know you got. I'm sort of asking you behind.
Right.
Ignorance.
So what I would say is, Your Honor,
I do think,
obviously we would,
as long and as eloquently as you argued about your client's, right to be heard in court. I think maybe you would say the government, as a matter of fairness, ought to have a shot at the Supreme Court if they lose here.
if that were going to happen and you were going to rule for the government on this, then I would hope that Your Honors would give us time to seek a stay from the Supreme Court without allowing everyone to be put on a plane to El Salvador in the interim. But I would urge this court to allow the district court to just finish its ruling.
I mean, if we're going to rule for you,
go ahead.
do you see that do you see the benefit of us doing that very quickly so that the government can get to the Supreme Court fast enough?
I will leave that to Your Honors, whether you think that
you don't have an objection.
I mean, we would prefer that you deny the stay request and send it back to the district court. And I don't think you need to rule quickly. I mean, I just want to leave with one point.
Real quickly, if we're going to rule against you.
Right. Well, exactly.
If we're going to rule for you.
Exactly. I just want to leave the court with one point. If the government is going to stand up on reply and admit that under Supreme Court precedent, people have to have the ability to contest, and that's a matter of Supreme Court precedent of the decade, the statute, and if you want to throw in due process as well and about the implementation, then it's inconceivable to me how they can say this is an intrusion on national security, because they themselves are saying, yes, at least that part of Judge Boasberg's order must stand. And so that certainly can stand until there's a preliminary injunction ruling. But I just don't see how the government can continue using this broad rhetoric about intrusions on national security if they're conceding that Judge Boasberg is right, as at least our secondary claim that there must be process, even if he was not willing at this point to rule on whether the Alien Enemies Act can be used at all against a non-foreign government.
Thank you.
Thank you, Your Honor.
Mr. Ensign, why don't you take 5 minutes?
Your Honor, I'll be very brief. Just 2 very quick points. I believe opposing counsel said expressly that this case could be brought in habeas. Under this court's decision in LeBeau, which I think I mispronounced earlier, that very clearly means that it must be brought in habeas. That is not in a distinguishable context. That was brought by
involves something that couldn't be brought under the APA at all, extradition. That's not this situation.
Your Honor, I think the same
Extradition is its own body of law.
It does have its own, but it is the same context of a person using habeas, or in that case, actually using it in a different court. But the fact that habeas was available to challenge a transfer to a foreign country meant that because habeas was available in habeas, it must be brought in habeas.
Before Munaf versus Green and Thursagian. And Munaf versus Green was also, the court recognized that there could be habeas and that it could apply to someone in foreign lands under held by a multinational force in the middle of a war, but American citizens would still have the right to bring a habeas, and then just said that you can't get this relief of protecting you against transfer to another government in habeas. That seems to be, and that did not involve, that was detention issues and transfer issues. It wasn't extradition, which is its own body of law and just sort of inept in this context. And there's no APA option there. There's definitely an APA option here. That's the point of Munaf.
Your Honor, I disagree. Both that LeBeau and Munaf involved challenges to attempted transfers to foreign countries. In both cases, the court said, though, in Abu, the court said that has to be brought as habeas, and because it could not be brought as non-habeas. And in Munaf, the Supreme Court said that can be brought in habeas. That was the first question presented that the court resolved by answering in the affirmative. And then under Abu, that means that it must be
Habeas is
brought.
available to someone named Manaf in this foreign situation. I mean, talk about interfering with the conduct of a war. But that habeas is available to people in his situation. But it's not, he wasn't seeking a form of relief that habeas could provide, which by definition, he didn't fail on some sort of individual merits. He said, this relief of stopping a transfer to another government is not available under habeas.
Your Honor, I heard my opposing counsel say to you directly that this could have been brought as habeas. And so I think Abu means it has
No,
to
I
be.
think what he said was people could individually, if given notice and time, bring habeas. Well, does the government agree that they could bring a habeas class action as long as they did it in Texas? I mean, if the habeas class action is going to have to be wherever these people are held.
Your Honor, I'm not aware of specifically case law barring that. I believe opposing counsel
Does the government
referenced.
have a position on habeas, the existence of habeas class actions?
Your Honor, I don't have a definitive position of the government. That was decided on an extremely accelerated timetable before we had an opportunity to file a brief, with any legal reasoning.
It's hard to figure out how you'd get past the class criteria because you're going to have individualized showings. But if it's allowed, then I guess it's allowed. It seems a difficult question. Seems quite uncertain question.
I mean, Your Honor, plaintiffs clearly take the position that they can bring so, and that they effectively got such class relief even before their habeas claim was voluntarily dismissed, I believe.
And so I guess what I'm trying to figure out is, you're asking this course, you've agreed, I guess they say grudgingly, I'll let you decide your own adverb, that you have agreed that these folks are entitled to notice and due process.
Your Honor,
That's not a violation of the DECI.
Your Honor, we've agreed that challenges to individual determinations can be brought in habeas, that there's precedents that recognize that, including Ludecky, which allowed people to bring certain challenges in habeas. And, I think much of this exchange has.
Before they're removed?
Before,
it certainly wasn't DECI.
in this case, this action was filed before they were removed and included habeas claims and obtained relief.
Are you agreeing that what they have a right to do is notice and an opportunity? Not going to be a long opportunity, I would assume not, but a reasonable opportunity, a fair opportunity to seek the type of review that's allowed under the AEA of whether you qualify under a proclamation terms. Do they have a right to do that before they're put on an airplane?
Your Honor, I think the answer that this court provided in IM is if you bring such a challenge in habeas before you're out of custody, that can be brought.
No, that's not my question. My question is, because the government's in complete control of when these people get put on airplanes or not.
That's a fact.
So my question is, I mean, if they're lucky enough to bring it, that's one thing. I'm not asking that question. I'm asking, does the government agree that they're entitled to notice based on their status as a member of the AE, the opportunity?
Your Honor, we don't agree to the notice. They can.
I don't know how you can habeas if you don't have.
Individuals did here.
So no, they anticipated it. They filed before there's even a proclamation. And so if we were to rule for you, it sounds to me like if we were to rule for you and vacate the TRO, the government considers itself fully within its rights to pack every member of this class, including the 5 named plaintiffs, onto an airplane before there's a chance, reasonable time to file habeas petitions. Is that correct?
Your Honor, I think as we've discussed right now, there's nothing preventing these
It is-
5 from filing a
That's not
habeas
my
action.
question.
It is.
My question again is, if we were to grant the relief you request,
Don't do it.
would the government consider it necessary to allow time, notice, and time to file a habeas petition before removing people under the proclamation? Or would it, anyway, that's A, or B, is the government's position that it could immediately resume mass removals of these 5 named plaintiffs and the class members immediately?
That's B.
A or B?
B.
If you've got a C, you can tell me a C.
Your Honor, I think it's B, that we take the position the EAEA does not
Mhm.
require such notice, but that certainly in this period, these 5 plaintiffs could bring habeas claims right now and are electing not to do so. They could bring it in the correct court, and they've identified no obstacles to doing so.
There's a whole class before us.
They're not talking just about 5 people.
You haven't moved to vacate the class certification. I don't know why you keep talking about these 5 people. We've probably got hundreds of people
Exactly.
before us.
He's being
And I'm
slick.
asking about those hundreds,
He's being slick.
including those 5. And as to them, I understand your answer is B. The second we vacate, if we were to do that, people are lined up and put on planes without notice or time to file for habeas,
They would do it immediately.
even though the government agrees that decision, they have a right to have the decision made about whether they even qualify under the proclamation.
Your Honor, if the TROs dissolve, the government believes there would not be a limitation and that the statute does not require such notice.
Does the government have any obligation with a class certified to notify council as to where these individuals are that are being removed, and so they even know which jurisdiction to bring a habeas suit in?
Your Honor, I don't believe that plaintiffs have sought such relief. I don't think the district court has ordered it. And so,
Not notice. It's not notice. And it seems it's the government here that says you got to file habeas actions. The whole solution here is habeas actions. Let's all have habeas actions. So it would seem a bit rich for the government to say, but we're not going to tell you where they are or where you need to file or give you time
And you can't do
to
that.
file at all.
You got to find the jurisdiction where the person was at.
well, Your Honor, they certainly know where their own clients are and they're refusing to file
They
in the proper
don't. They
court.
don't even know.
They don't know what
many are
they're
in
at.
this class. You
As,
can talk about 5. They represent way more than 5. I don't understand why we're just talking about 5. That's the point of class
He's
action.
deflecting y'all.
Your Honor, they could certainly file in habeas. They seem to care about their
They can't
form
file
more
in
than
habeas unless they go to the right.
They need the
jurisdiction.
jurisdiction.
I absolutely agree with that premise, Your Honor,
But if
which
they
is why
don't
they
know
need
where
to
they
file
are,
in Texas.
And the government won't tell them.
They know where at least some of them are,
They need
and
to know
they're
all.
they're
Everybody
affirmatively
else.
refusing to bring habeas in those jurisdictions.
And
Uh,
there's no refusing, they've declined, they've made a choice not to, that's supported by an awful lot of precedent. But that's not the point. The point is you must know how many more people are in this class.
But he's just
Your Honor, there is a declaration that provides the estimate. I believe it's the CERNA declaration, filed on Tuesday or so. I don't recall the specific numbers, but it is in the record.
Are we
That's what
100?
you
I'm
should know.
sorry, I looked at
My
it.
recollection is it's in around 300 or so.
300.
wow.
Is every one of them in the same jurisdiction in Texas?
Your Honor, I don't know that question.
Okay. They don't either. Hard to file.
They don't either.
The other thing I just wanted to clarify is, it seems like you're sort of both crossing over here. The written TRO doesn't say anything about bringing airplanes back. It just says that you shall not remove people that are within the class. But it was in his oral direction, which you say was not, unless I've misunderstood the position. My understanding from government's position in district court is that was not a binding order until it was reduced.
That's
to
not
writing.
true.
And so when you're asking us to vacate the TRO, are you asking us to
Or argument
vacate
too.
the written TRO, which is one that you say is legally operative?
That is what we are asking this court to stay or dissolve. But certainly, I think plaintiffs are taking the position that that incorporates more than what is it within the 4
But you're
corners
not.
of its writing.
Right.
Right.
We take a contrary position, but jurisdiction in no way depends on the merits, as the Supreme Court has repeatedly explained.
Okay.
Um,
Right, you want to wind it up?
Yeah, very quickly, Your Honors. On the habeas point, you've heard that it could be brought in habeas. Review means that it needs to be so. We've also heard from opposing counsel right now that they intend to bring evidence of individual cases. I think that's important for two reasons. It is in severe tension with commonality requirement of a class. They're now getting into very fact-bound characteristics that are inconsistent with class adjudication. And I think it just again underscores how much this is sounding in habeas. My particular circumstances warrant you not exercising custody over me is a classic habeas claim, and it should be brought as such.
Thank you.
Your Honors.
They got to keep this as a class because they don't know what half the people, they don't know what 90% of people are at. They don't know where 95% of where the people are at, but they want to have a habeas corpus on all of them. Well, you need to know where everyone's at. The government hasn't revealed where everyone's at. And a lot of them out of the country. There are only 5 that he's honing in on, the government. But as the judge said, this should be a class, not just a habeas. But you can't file a habeas class. So the problem is that when President Trump issued this order, it wasn't done in public and didn't give anyone the opportunity to lawyer up, to prepare for these deportations. And now the lawyers arguing for the class that there was, 1, no due process, and 2, the government never gave anyone an opportunity to object to this by way of, hey, I'm not part of a gang. You just, and something the judge said early on that I don't think you guys had an opportunity to hear. She said that if they allow this to stay, if they give the government what they want, then she too could be someone that could be deported without any due process. So why the government didn't want to give people a due process, bring them in front of an Article 3 judge and let the judge determine whether or not that person is part of the order or the executive order that Trump signed. So this doesn't sound like the administration. The administration is trying to use a backdoor approach to this, and I think that's going to be the problem. I think that's going to be the problem right now, and I think the government is probably going to lose on this. I think the government is going to lose on this. I think the court is over. Let me just go ahead and give you a widescreen this. I think what's going to happen is the court is going to let the district judge's TRO to stand and allow the detainees, the ones who have lawyers, to fight this detention, because we don't know who in the 300. We don't know who in the 300 that should not be there, and that's just an estimate. For example, the Columbia University student Khalil, who was taken into custody and treated under this order of the Trump signed, he is arguing that he's not part of a gang. He's not supporting Hamas, but he is a spokesperson for the campus and the liaison between the campus and the students who are pro-Israel. So it's very tricky. If you give Trump this kind of power, then he can absolutely, through his czar, round people up. And we don't know who those people are. We don't know the names. Do we even have can anyone right now watching this stream tell me, do you know the names of the people that are in detention? Do you know the names of people in detention? We need to see the manifest. Also, what we don't know is what time did the plane take off, and did the Trump administration violate the district court's oral order as well as their written order? So there's a lot of things that we don't know. And the judge, Judge Millett, she said that she has a way of finding out, but why doesn't the lawyer represent the government just give the judge? That's not a secret. They're not here anymore. What time did that plane take off? Why is the government lawyer hiding that information from the judge? It seems like he has the information he needs to convince the judge the judges, the 3-judge panel, to make a determination. He hasn't brought that forth. So at this point, I think listen, if they're bad people, give them the due process and allow the Article 3 judge to make that determination. And if it's found that they have done the things that is alleged under this administration's order, then ship them out. But if it's to the contrary, you got to bring them back, because otherwise, first it'll be them, then it will be us. Let that sink in. First it will be them, then it will be us. Because if you're just rounding people up because you believe, and in the case of Mr. Khalil, who's a Columbia student, they rounded him up. And from everything I've read, this guy, he's not doing anything radical. We heard the press secretary say that there was some kind of leaflet, a Hamas leaflet that he was passing out. No one supported that statement. No one supported that statement, and they're just saying anything right now. You just can't make stuff up. You got to have facts. And she said this in the press conference last week that, he had a leaflet that was supporting Hamas. But first, where's the leaflet and where's the proof that he passed it out? Pass it out. So it's just getting very dangerous right now, ladies and gentlemen. And this is getting so dangerous, and people have to wake up, because if he's able to do this, like just throw people on planes and just take them out the country without giving due process, that's crazy. Because then it could be a family member. It could be your family. Right now, you have one of the husbands of one of Portia Williams' ex-husband. He's sitting in a detention center in somewhere in Georgia, and they just rounded him up. For what reason? We don't know that. We don't know that. So the way it's and we're not in wartime. So this, as the plaintiff's attorney said, that it was only 4 times that this measure was used, and they were all wartime. We're not in wartime. If they're a gang, they're a gang. I mean, you can say this is a domestic war, but when I hear wartime, I'm thinking we're at wartime with enemy combatants that are coming from other countries, like 9/11. But this is not that situation. And if it is that situation, the government has to put this out in public, because the risk of not doing this makes Americans very skeptical of the process. And again, my belief that the appeals court is going to uphold the district court's decision, because there's too many questions that are not being asked. They're not being answered. So I believe that the court, even though one of the justices did say that what happens, and he kind of signaled, it seems like he was going in the direction of affirming the lower court and giving the government opportunity to file an appeal with the Supreme Court. He kind of alluded to that, but he didn't actually say that was his direction. But I think all the signs show that the district court's TRO is going to stand. It's going to stand. I think they should continue challenging things that has been unprecedented in this administration. You got to keep challenging. No, and this is the process. Not calling for the impeachment of judges. You know, if it's district court makes a ruling, then the next process go to the circuit court, and then to the Supreme Court. But the way some people in the administration want to do, they want to impeach judges who are not lockstep in Trump's decisions, and that's not how the country works. There are 3 equal branches of government, and there's no kings. There's no kings. There's no kings ruling this country as it stands right now. And I think we got to pay attention, because it's getting dangerous right here now, ladies and gentlemen. It's getting very dangerous, and we cannot ignore this, because the Republicans control the House, the Senate, and they have the majority on the Supreme Court. While certain justices are not ruling in Trump's favor in a lot of instances, They have dissented. They have said, nah, this is not the way this is not how America is. And I think that's important. Before I go, I want to talk about that audio that was leaked, purporting to be Vance, Vice President Vance, putting Elon Musk on blast. Well, the vice president said that that's AI generated. I don't know if it was AI generated because the way the sound came out, I don't know. He may have got a spanking from the White House, but it did sound like it was Vance. But he's saying it's not him. The person who made the post is still up. Twitter hasn't taken it down, and again, he's saying it's not him. And I guess if he says it's not him, I guess we have to. I mean, anyone's being recorded without their knowledge can come back and say, "Hey, that's not me." Well, we need more proof than that, ladies and gentlemen. I'm not buying that. I'm not buying that it wasn't him. I need proof. I need that person who uploaded to, we need to know who your source is, because you can file a defamation case. He can file a defamation case, but I don't know if that will fly because he is a public figure. But again, it brings back to the questions that people are saying that AI is dangerous. People are making. I don't know the app that they do that with. I don't want to know, but if I see my voice on AI, we're gonna have a problem. I'm suing you. I am suing you if my voice pops up on AI. I don't know, ladies and gentlemen. This is. I mean, the way that how hollow it did sound like he was being recorded. It sounded like he was being recorded. It sounded like the recorder was in a hidden place, and it gave you all the impression that this was a secret recording. But he's saying it wasn't him. Let's just say this: as embarrassing that is. Do you think he's going to take ownership of that? Let's be honest. You think he's going to really take ownership of that? I mean, do you think that the man who's basically being ignored as the vice president, Elon Musk is basically in the White House cabinet with Trump all the time, and we rarely see Vance in the White House? I don't know. It does appear that they're doing damage control. It sounded real. I'm gonna tell you something. Listen, I listened to so many recordings in my time. Listen, I got real recordings that sound like Vance, not Vance per se, but hey, let me turn the recording on. And so, but Vance is saying it's not him. Do you guys believe that? Do you guys believe that for real? Be honest. Listen to it and listen to other recordings. That sounds so. I mean, listen. Whoever did that put a lot of work into it to make it sound so real. But if they put no work into it, it might likely be real. Who knows? But I just hope that the circuit court, the Court of Appeals, allows the district court's this decision to stand until they give these, not just the 5, but the whole entire class. The entire class. You need every individual person who has been taken. And to think about this. And I had to go there. My ancestors were brought from another place into America. We don't know who all they were. But that happened. And if they can just do that to we need to know all the people. I don't feel comfortable, just looking at a well-edited video of what is purported to be gang members being deported. Listen, that production was a nice production, but that doesn't tell the whole picture. It doesn't tell the whole picture. And you have to be intelligent enough to know that when you're watching television, it's telling you their vision. You don't know for a fact what you're seeing is actually real. So we need to see the source documents, the manifest of every individual that got onto those planes and where were they taken to. They might not release the part where they were taken to, but we need to still see who the individuals are and what are the claims against each individual. They deserve due process. No one should fight due process. That is the American way. That is the American way. No different than all the enemy combatants who was in Guantanamo Bay during both the 1993 bombing in New York as well as the World Trade Center bombing. They all got due process. Some stayed in longer, but they were ultimately prosecuted and found the ones that were actually combatants, they were prosecuted and convicted. Others were released. So is this that case? Is this that case? We don't know that. And no one should be comfortable with that happening as an American. No one should be comfortable with that. And Jordan's asking a good question. How do we know that any of them are not American citizens? How do we know that? How do we know that? We don't know that. And that's the concern that people should have. How do we know? And by the way, I'm an American citizen. I am an American citizen. So me speak great English. But how do we know that any one of those individuals who pissed off Trump or his allies is not one of the people that was shipped off? Let's put them in the plane. Let's put them in part of the bunch. We don't know that. No one can tell me they know that for a fact. And it's until we know that, as tax-paying Americans, we should not be comfortable with that happening because it could be an American in the mix. I got nothing to worry about. But nah, I'm from the Bronx. I'm from the Bronx, baby. But we need answers. We need them, and we need them now. How about that? With that, ladies and gentlemen, I do appreciate you guys joining this impromptu live, because I think this is a very, very important court hearing involving a serious matter. This is not something that, I know we can, I got some other good, cool stuff to talk about, but this is of national importance. This is to protect the Constitution. Nothing overrides the Constitution. And due process, I want to say if the Eighth Amendment, somebody can Google this, I believe it's due process is in two clauses of the amendment of the Constitution. The due process is referenced in two amendments in the Constitution. And I'm not seeing due process here. I'm just not seeing it right now. And we need to see that. Let's just be honest. We need to see that. Trump got these streets quiet. Jordan, what does that mean? Jordan, what does that? Trump got these streets quiet. What does that mean? Because I'm not quiet. What does that really mean? He got these streets quiet. Shout out to Harper Blue. I see you in there. Let me see. Let me run down that. Listen. You guys better. You know what you got to do. Let me know you're in the building. Make your comments stand out. Let's see here. Let's see here. Shout out to Jordan, because Jordan's been engaging. Jordan has been engaging. So Black Cappuccino said the CIA and the NSA knows things we don't know. Yeah, okay. And I know things that you don't know. How about that? Let me just put that there, right there. Yeah. Oh, that sounds good. It's a nice talking point, but we need to know specifics. What's the secret? If you're shipping someone off because they're a threat, then you might as well put it out there. There's no secret in that. We need to know. You're not going to beat me in the head with alphabets. You're not going to do that. That's not happening. Jerome Street was good. Okay, so let me go ahead. Let's say what Jordan said. Jordan said that means that non-citizens are not out acting a fool like they were before they came. Okay, well, I mean, I would agree with you, Jordan, in one respect. If you are holding a visa, or you're not a an American citizen, it would be stupid to be bringing unnecessary attention towards yourself. I would agree to that. But that doesn't take away from you having the right to have your day in court. And no one should be comfortable with no individual not having their day in court. There's a process. You can't circumvent the process unless, and we got to be able to, it got to be a check and balance with that. You can prove, not just because of the government say, come on now. We've been lied to on both administrations. We've been lied to. It is what it is. The American people have been lied to by both administrations for many years. We need transparency when it comes to people being removed from this country, and we need to know if they're Americans. How do we know none of them are Americans? For example, Khalil, again, Google the story. He's a Columbia student, and those who know the story understand what I'm talking about. He had his American citizen status. He finished college. He was a graduate student at Columbia, and he was a mediator. Because you don't like his speech doesn't mean he's an enemy of the state. And I think that's what the family's arguing. Because you don't like his speech. He earned the right to speak in this country. He attended Columbia University. He became a citizen. But because you don't like his speech, it's nothing wrong with him standing up for his countrymen if he sees atrocities happening. He has the right to speak up. No different than Elon Musk being a South African who speaks up on Twitter every day about what he believes is discrimination against the people he left behind in South Africa. So why is his speech better than the person who's speaking out for people in his country? They both are citizens. Elon Musk is a citizen as well. I don't know if you guys know that, but he is a citizen. He got here in 1992, and he became a citizen in 2000 something. Right. No, but Jordan, Khalil is not a green card holder anymore. He's a citizen now. So I don't think that we should be comfortable. Again, I'll say that until you can prove me wrong, that we can be comfortable with anyone just being shipped out this country. We want to make sure no one's getting caught up in a web of a web of getting even with somebody. No. The court is gonna. I would be very uncomfortable with a court coming back and saying, "Oh, Trump can do it. He can let." They're not lifting this TRO. That TRO is staying until it goes through the process. And there will be more lawsuits this week filed, guarantee you, to address the class. Because again, the government's lawyer is honing in only on the fathers in Texas. Nah, you got 300 people sitting somewhere. Who are those 300 people? And that's what the people want to know. That's what they want to know. With that, ladies and gentlemen, thank you for joining. Those who are watching on Twitter, this was, a topic that I don't typically talk about, but I'm going to be a little more vocal. I'm going to have to be a little more vocal. I'm not liking what I'm seeing. I'm just not liking what I'm seeing right now. But if you are someone that is doing harm to Americans, are you American domestic terrorist or someone that is a enemy combatant? You got to get up out of here. You got to get up out of here. But you do deserve due process. You do deserve due process. And we'll just see how this plays out, ladies and gentlemen. With that, I'll see you on the next live. Peace.